Thank you, Chinmayi. Is this okay?
Yes.
Hi, everyone. Thanks for having me. It really is a treat for me to be here. My name is Olivier Sylvain. I teach at Fordham Law School, and I'm a senior fellow at the Knight First Amendment Institute, which my time there is ending this spring. I'm here to talk about the book and a further argument I make in a book chapter for ANNALS that really got prompted by an invitation from Tracey Meares, who convened the session last spring, among a bunch of us who think and write in law and tech, and I wrote a paper, my chapter on middleware, which builds on ideas in the book. But what I want to do here is be a bit more experimental and gesture to a next project. And the title of this meeting indicates where I want to go. And I think the title is something like "Code is not law after all." That part is not fully baked, but I'm certain I have an audience here who will help me, if not push me back, tell me not to pursue, or to pursue it a little more carefully than I intend now. So I understand that I have between 30 and 40 minutes to present. That feels like a long time for me. So I hope you have questions, along the way, if I'm not being clear. If not, I'll keep going with the anxiety that for me engenders. And then, we'll do Q&A, I hope. So I will start with the developments of the past couple of weeks in trials that you are all probably aware of. There are trials all over the country where large tech companies, really social administrators of social media services, social media companies, are defendants in cases brought by families and individuals for causing harm. And the theories that have prevailed over traditional statutory and constitutional shields that the companies invoke has been the design theory, theory that the companies have built services that are products, and that there are foreseeable risks and harms that they don't do enough to redress before they put them out to market and even after. And the big trials, as you likely saw, ended in jury verdicts for the families. This is momentous to me, and I think many people watching, because there have been very few occasions on which these companies, here the cases were against Meta and YouTube, Google's YouTube. These companies are held accountable for what many of us intuit, and that the harms, the consumer harms that flow, particularly to young people. The statutory and constitutional protections I'm talking about are two that I assume many of you know about. One is the First Amendment, and much of the logic of this defense flows from the Supreme Court's decision in Moody versus NetChoice from a couple years ago, but even preceded. The First Amendment shields companies making editorial decisions about the content they deliver. The other is a statutory protection that, under some people's description, immunizes companies that traffic in user-generated content. And that protection is enacted in the US Code in the 1990s and has an early embellishment by a Fourth Circuit court that endures. And it's a protection that companies evoke to shield them from liability for harm that they allege arises from third-party content, not content that they've produced. The cases prevail over, the couple cases prevail over these defenses, as I said, because plaintiffs' lawyers over the past few years have discovered a way around the protection, and that is to not address the complaint to content or the delivery of content, but again to the ways in which the services are designed. In the context of the First Amendment, the argument is that this is not expressive, that the issues that the stakes are not expressive, but really baked in or related to the construction of the service, the design of the service, and on the context of Section 230, that these are not about user-generated content, but about the ways in which the companies facilitate or actually deliberately design services to engage their users, their so-called users, right? And this theory under Section 230 asserts not merely that they're materially contributing to content. It's not really that, which is, you know, an important wrinkle in the 230 doctrine, but that these companies are responsible for the ways in which the services work in the first instance, unrelated to the content, because they want to hold attention. I think I need a little water right here. In a second. No, I have water here. Okay, so that's the contemporary setting. This development is a long time coming. These verdicts are a long time coming. The companies will appeal these verdicts, but for the past 10 years, I and a handful of others have been arguing for a design approach to the way the companies work as a way to get around the Section 230 defense, but it certainly works out in the context of the First Amendment. I'm happy to hear thoughts and questions about this. As I say, it's a long time coming with regards to holding companies accountable on the substantive violations of law, right? The protections I've mentioned shield that inquiry, right? We never get to the substantive question because companies can invoke Section 230, 47 USC 230, or the First Amendment to shield the inquiry into whether they're liable. We have two decisions here that indicate that they are liable. Juries have decided that. Companies will appeal, to be sure. A long time coming, as I say, because people like me and a handful of others have been arguing for this theory, and courts over the course of the past decade have been warming to it. The one case that I'll mention that some of you likely know is a Lemon versus Snap case from 2019, I think, Ninth Circuit. Ninth Circuit here is a case in which parents are upset that their young people, their children died in a car crash. Why did they die? They had the speed filter that Snap makes part of their available part of their service. And the speed filter is very attractive to the kind of person who is thrilled by going fast. As it turns out, young boys with driver's licenses are an easy target for this. These young boys are under the impression that they'll get rewards if they go fast. That may be a mistaken impression, but that's part of the alleged harm. And Snap knows that there are these possibilities, but doesn't disabuse people sufficiently about the potential for risk. And this is in the allegation. The company, in the face of the complaint from the families that these young people died because of the use of the speed filter, invoked Section 230. They said, no, we can't be held accountable. You can't evaluate whether we're responsible because this is user-generated content. And Section 230 protects us from being held accountable for user-generated content. What's the user-generated content in this context? It's their speed, right? The young men's speed. This strikes me as a remarkable, even perverse invocation of the 230 defense. The court, the Ninth Circuit, sees through this because the plaintiffs allege a negligent design theory. This is not about user-generated content. They built this service recklessly. They should have known that there were going to be young people who would use the speed filter in this way. So again, that case doesn't resolve whether they are responsible, but it does open the possibility that they could be. And for those of us who've been talking about this, that's all we've been arguing, right? an opportunity to evaluate whether they are liable. Why is this important? Because that's the very thing that we expect from all stakeholders in our democracy, right? That one way or another, we hold them accountable if they're responsible. And the companies in this setting have been safely protected for a long time until recently. And one of my more provocative claims is that there's only one other industry that enjoys this kind of protection in the United States. It's the gun industry, as a constitutional and statutory matter. There are a lot of people who like to talk about nutritional supplements in this setting, but they don't, the manufacturers of nutritional supplements don't enjoy constitutional protection the way the gun manufacturers and social media do. Okay. If this is an acts, this is Act 1. I want to now go back to that moment when these protections emerge. That's the 1990s. It's a heady time, and all of us who are thinking about the internet are excited about what's possible. But there's a lot of buzzy, head-spinning language that people are using to talk about the emergent technology, the emerging network communication technology. You all likely know, or you may have heard of, John Perry Barlow's Declaration of the Independence of Cyberspace, where he is principally concerned about a provision that Congress wants to pass that would aim to block the distribution of pornography to children. Section 223. This is a provision that the Supreme Court strikes down, and later on in Reno versus ACLU, which I'll also talk about. But the 230 protection is there, which is not 223, which is the address to porn, is there to ensure that there are so-called platforms for the distribution of user-generated content to ensure innovation and free speech online. And this is the mantra that the developers of this language use is user control, right? That users ought to be able to decide and adjudicate for themselves what information they absorb, and that the platforms are just facilitating that democratic opportunity. I'm happy to talk more about this moment. For what it's worth, this is not a provision that gets a hearing before a committee in the way that Section 223 does. It's actually added on the floor by two prominent representatives, Wyden and Cox, in the House, and it becomes part of the law. It's a response to litigation in a couple years before that could have arguably held the companies responsible as publishers of third-party content. Section 230 removes notice liability, right? It says that even if you have knowledge of bad stuff, unlawful stuff, that is generated by others, you can't be treated as a publisher. A year later, after the statute is passed, the Fourth Circuit says that this is a broad protection, not just for publishers, but also under First Amendment doctrine for distributors. That means even if you know, even someone tells you there's harmful, dangerous, unlawful stuff, you can't hold these companies responsible. Again, the logic the Fourth Circuit here uses is about user control and a great possibility for democracy. A case that is decided that same year, 1997, involves the First Amendment, and that involves Section 223, the anti-porn provision. And Justice Stevens, in his opinion for the Supreme Court striking down Section 230, uses the most purple prose to talk about the internet, where he mingles and mixes different applications of the internet. Email is the web, is electronic and bulletin boards. This is the same, by the way, move that the Fourth Circuit does, Judge Wilkinson, Chief Judge Wilkinson, the Fourth Circuit does with regards to Section 230. No nuance about what the internet is and its different applications. It's just a really happy story about the romantic possibilities on the internet for democratic transformation. Why are they saying this? They're not making it up. Maybe they didn't read John Perry Barlow's Declaration of Independence of Cyberspace, but they're imbibing an ethos that's in the air, that's shared, that many of us had at the time. I like referring to John Perry Barlow's Declaration of Independence of Cyberspace, not because of what he writes, but because of he ends the poem, the manifesto, with an indication of where he is. Davos is where he pens this, February 1996. Now, I don't know if any of you were around February 1996, but maybe you know what's going on in the world in February 1996. You all likely know what Davos is, right? It's this fancy place where thought leaders and industry leaders meet, big name scholars come, writers to talk about difficult things in the world. Barlow's declaration invokes this is drawing on this air at the time that people share. But in 1996, people around the world are protesting globalization. There are protests in Seattle, there are protests in Paris, there are protests all over the world about unrestrained globalization. I'm not a scholar of international trade, and I just learn about these things from others. But I know that this was, at the moment, an important concern. Not a word of it in the Declaration of Independence of Cyberspace. This, for me, is not an accident. And that is because this language, this rhetoric of democratic transformation is in service, unknowingly perhaps, but is in service of a longstanding ideology about trade and innovation and freedom, at the expense of another story we might tell about exploitation, repression, subordination. None of that, right? What you have instead is a concern about governmental overreach. The Fourth Circuit adopts this doctrine in the context of Section 230. The Supreme Court adopts this ideology in the context of the First Amendment. And the First Amendment doctrine continues to grow over the next few decades, as many of you know, shifting not just to ensure that users can speak freely online, but that companies that are providing services can speak freely also. So the Packingham case out of North Carolina involves an individual's right to post whatever he wants online, as long as it's lawful. And the net choice, the Moody versus net choice case from a couple of years, enshrining the view that the companies exercise First Amendment right. This is a very expansive, broad view. It isn't obvious that this broad view ought to prevail, to me. At least because these are companies that have, by the early 2000s, discovered a business model that ought to make us think more critically about whether this is a classic First Amendment problem or not, in my view. It is a business model that promotes the services and content on the sites in order to target content to users, but also, as you know, to hold their attention. Whether that warrants the strictest of scrutiny at the Supreme Court on the First Amendment doctrine, for me, is the question of the day, and precisely the kinds of things that we're seeing courts adjudicate around the country. But this is the enduring ideology of the 1990s, and it has stayed with us. It is of some irony that I am leaning on Justice Thomas and Justice Alito, two justices whom I do not have a lot of admiration for, and that's because in concurring opinions in the Reno versus ACLU case and in the recent Moody versus net choice case, they say we've been doing this First Amendment analysis wrong. We've been talking about the internet and internet applications as if they're all the same. Why do and Alito, in his typically acerbic way, is rather angry and dismissive about the majority, Justice Kagan's language for the court that talks really in a blanket way about the internet. He said we should be more careful. We might be able to regulate some applications. Thomas has similar views in other occasions. This is an important recognition, in my view, about what was missing in the 1990s. Nuance, attention to detail, not being taken by ideologies of freedom, blanket ideologies of freedom. By the way, this concern about nuance is precisely why the Ninth Circuit in Lemon versus Snap, the case I described a moment ago in the context of Section 230, changes the tune on the 230 doctrine. And it's because the Ninth Circuit says, we have to look at each application differently, or each design feature on a platform, so-called platform, differently. The infinite scroll, or a speed filter, or autoplay, video autoplay, are not about the content that users are generating. These are design features that companies use for to advance their own pecuniary ends. This is, again, a nuanced term. And if there's anything in my book that I'm arguing with regards to the doctrine that's gotten wrong, it is an insufficient attention to detail. It is taken by a language and rhetoric of transformation and freedom, very seductive. I mean, it goes back to John Milton, right? I mean, this is, in the Anglo-American tradition, deep and strong. Ronald Coase draws on it to critique the Federal Communications Commission in 1959. It's no surprise that this surfaces as a prominent argument. But the lack of attention to detail, especially with regards to consumer-facing applications, is worrisome, and I'm very happy to see that we've taken a turn. Maybe that's the end of Act 2. I'm ripping here, okay? I mean, I've spoken about these issues before, but this organization is a little different. Now I want to talk about a very contemporary debate that gives me pause, because I feel as though we're falling back into the same rhetorics. We, policymakers, scholars, policy elites, are invoking the same sort of ideologies to justify certain kind of reform efforts. And here I want to talk about advocates, mostly on the left, but also on the right, who are championing user controls again. And this category of intervention I associate with something called middleware. It's not my invocation. Other, people who are smarter on the technology have invoked it. And when I talk to computer scientists, I don't know how many of you are computer scientists here, or engineers. I think when we tell an engineer or a computer scientist in particular, you say middleware, they'll say, you're not using that word the way that I use that word. And that's what I've learned. But basically, the way that legal scholars have been invoking it is it's a layer between the applications and the users that affords them the ability to control their online experience. The most elemental and pervasive one might be a browser extension that allows you to tweak and control your privacy in different sites you visit through the browser. But there are more elaborate interventions. There are protocols that promote user control. How many of you are on Blue Sky? Right, it relies on no one. That's okay. There are some of you. That's right, some of you. Mastodon is another celebrated social media derivative. Anyway, these are premised on protocols that ultimately allow consumers to make choices about their algorithmic feed, or to control their algorithmic feed altogether. User control. When I was here a year ago, Ethan Zuckerman, who is an extraordinary scholar in information studies, media studies, communication studies, Amherst, was at the MIT lab and left for admirable reasons, is now at Amherst, UMass, writes about this. Many other people, Renee DiResta, Mike Masnick, luminaries in areas of information law, are advocating middleware. Why? This is a way to resist the power of the powerful platforms. Give users the ability to control their online experience. And there's something very, again, seductive about user control. It, as I say, it's associated with the founding moment. But I can't believe, and I say this with respect, that we would return to that same convention given where we are today. Not that that isn't a seductive and normatively attractive language, user control, it truly is. But given what we've learned about the information asymmetries in the network information economy, I can't believe that we would resort to the user as a remedy. Companies design their services behind, never mind the statutory and constitutional protections, they operate their companies behind the screen, as Sarah Roberts has written. in ways that are hard to understand and explain. And to assume that users in any given circumstance will be in a situation to moderate and control their online experience is at least a half-truth. I think that there are some users like Ethan and many very capable technologists who can understand the way in which some of these user controls operate. But I don't have to be a behavioral scientist to make the point, I don't think. I mean, it would be helpful if I had the empirical data, that the reason these user controls aren't taken up by conventional lay people, right, is because of the capacity, time, sophistication it takes to actually know what kind of levers and knobs to turn to control your online experience. The companies realize that, and they actually, there is a market for moderation. Even on any given platform, you can control certain aspects of your feed, and even across social media, there are varieties, right? Telegram is not Parler, is not Twitter, is not TikTok, right? There are different ways in which you can make decisions about the content you receive. So it isn't a surprise that this hasn't been taken up in my mind, and it feels like a luxury in the same way that John Perry Barlow talked about the internet in the 1990s. Not as an infrastructure for socio-political economic engagement, but as something else. And what this language does is mask the deep information asymmetries for which there are remedies, public law remedies, interventions that have been missing for too long, and the ones that I end my book on, right? Proposals addressed to not just narrowing Section 230's protection, that is to narrow it so it doesn't include, or that companies won't invoke it in the context of design claims, but also data protection law. The business model that emerges in the early 2000s that Facebook really innovates with mastery, personalization, and in the newsfeed that enables the targeting of ads. This is the kind of thing that the protections have enabled, and I argue that data protection robust, comprehensive data protection laws would get at the business model, right? The reason that the companies operate they do is because they can collect and share and monetize consumer information freely without concern for downstream consumer harms. I think I've spoken a lot, actually, at this point. I want to now finish with where I'd like to go, and this is the provocation. The eminent Lawrence Lessig writes a series of things, but the book, I think many of you heard of, his Code is Law, whereas his intervention, I still teach it in my classes. It's so enduring. And the main argument is that there are four ways. There are many arguments, but the one that I think people draw out is that there are four ways that policymakers should consider are useful for regulating behavior. One of them is government promulgated law, liability rules. Other is by thinking about norms. You don't have to legislate those, that they are extant in the world, and we might attend to them. Sometimes people associate this with standards in the technological setting. He also talked about the market. The price mechanism is another way of regulating behavior, and this is something that Hayek argues for, right? Free market advocates recognize that there's a regulation in the market itself. But his real intervention is that code writers, but code is another way of regulating behavior. And what policymakers should do is to ensure that, given information asymmetries, that there are mechanisms that allow the developers of code to protect or regulate behavior. We might think of this as not just about code, but about architecture. That's the language he uses. So in a room like this, it's designed this way, not because law says it, but it's designed this way to engender a sense of trust in what I'm saying. Somehow I am an authority, or maybe not, or at least for the moment, someone you should be listening to, even if you don't want to. That's an architectural feature, that's a design, that's code. And the newsfeed, the search rank results, those are regulating behavior. Yochai Benkler writes years ago with other sociologists, he's a legal scholar writing with social scientists about how nobody goes past the first page in the search results. Regulating behavior, right? And so it's an extraordinary intervention, I think, very useful intervention. And it is the kind of logic that justifies Section 230. It's the kind of logic that also justifies the Digital Millennium Copyright Act, which creates a safe harbor for companies. How so? The view in the 1990s was that if you let the companies free of the worry of the chill of lawsuits, they'll come up with design features that will be responsive to the public. There'll be some companies that will produce services that attend to pornography and obscenity, some that won't, but it's impossible to impose these obligations, especially if they visit First Amendment free speech concerns. And so 230 rises from the same sort of revelation. And it's not, Lessig is writing with Cass Sunstein and others who are thinking about behavioral interventions in regulation. So I think the cases of recent, the developments of recent underscore that code is not law. Code might be, that is the code writers, the developers of the designs of these services, in fact, might be working on contravention of law. And by law, I want to develop a legal process conception of what law is. It's a process of legitimizing collective action in democracy, at least in democracy. And as someone who teaches administrative law, who thinks about public law, I would love for us to start thinking seriously about the public law processes as the ways in which we sort out obligation, and not assume that code writers are the ones that ought to be the architects of that. There's much more to say about this, but I'll stop here. Okay. If some of you need to go now, please, I know that there are classes, right, or something. So. Yeah.
So really fascinating talk. I'm just wondering, what are the sort of limits of using tort in order to tort in order to deal with this kind of regulatory problem? You mentioned the recent social media cases, affects a handful of plaintiffs. The damages aren't that significant. To what degree is tort actually a useful lever here? It's obviously not something you have really outside of the American system. Is it one that we really want to hold up as a essential way in order to regulate these platforms, or is it just sort of the only?
So the two trials ended in $6 million verdict and a $375 million verdict. The first is just because there's one bellwether plaintiff. So there's compensatory damages and that both YouTube and Meta will have to pay, and then we'll find out about punitive damages. The other one is a case on behalf of the state, New Mexico, and it's addressed to a bunch of services on behalf of a variety of people. That's why it's $375 million. That's a lot of money, but you're absolutely right. For these companies, it's a drop in the bucket. It might be cost of doing business, to put it crassly. Right, and just to underscore why it's crass, we're talking about downstream harms that are pretty sad, some involving self-harm and suicide of young people. But I absolutely believe that tort is essential in the United States as a regulatory source of regulatory authority. And that is because at least this trial, the bellwether trial, is one of thousands. There's an MDL, multi-district litigation in the Northern District of California entertaining these same arguments. In New York State, there's just a new story about New York State the New York AG entertaining lawsuit as well. And the talk these days, talk to press about this, the thing that people are talking about is whether this is a tobacco moment. What happened in 1990s, we had these individual tort actions, but it ended a massive settlement that ultimately did change the way in which these companies operate. It ended up in legislation also. But for me, this is part of that process. And this is the legal process. By the way, I don't know, I actually don't have a position on what role tort plays. I know it's invaluable, especially at this scale. I think companies will make decisions about the ways they design services. Mind you, these are companies that, in the wake of Donald Trump's election, and even in the months before, decided to pull away from safety and trust and safety on their, self-regulation. They might have think twice about that. And I suspect that they are beginning to do that. But if this translates into litigation that resembles tobacco, I think you can expect fundamental reform. But I go even bigger, right? I would love to see statutory interventions, regulatory interventions that are aggressive. And I talk about data protection in this regard. I don't think you can just attend to the design of these services. We policymakers have to think about the business models that are at work. So that's why I'm certain tort is not enough, and that's, I think, part of what you're getting at. But it's a suite of interventions that is necessary. No industry enjoys this kind of impunity other than perhaps the gun manufacturers. Mike.
Thank you so much. This was a really, really, really fantastic presentation. I'm so excited to see where this project goes. So, very, very high-level question, and in a way, trying to sort of ask a little bit about the before of your story and where this is going next.
The historian is asking for the before.
Sorry.
No, it's good. I'm glad. It's good.
But your invocation of legal process.
Yeah. Okay.
Thinking, and we're not, we're down the hall, of course, from the Foundations of American Legal Thought course.
Yeah.
No one can at me in here, hopefully. But if we think about it like a broad historical way, kind of legal process school of public law, reasoned elaboration, all this in a way is really kind of seen in a certain sense as a response to mass social mobilizations and disruptions during the 1960s. How is it? Can we find a better way to insulate legal institutions from, the sway of politics? And so this makes me wonder, the moment you begin with, right?
Yeah.
Of saying, okay, isn't it ironic that we have, what's his name?
Thomas and Alito?
The Declaration of the Independence of Cyberspace.
Right.
John Perry Barlow writing in Davos while there are protests about, globalization in its various manifestations. And so one response to that moment would be to say, well, it's clear that the protests, the movements were not well integrated enough. It wasn't clear that there was a message, or another response would be that governments found some way to basically get around the demands of social protest without engaging them directly. So my real big question is what is the relationship between, law and social protest through the lens of technology? And what is your story about the internet? Tell us where we can go next.
Okay. Yeah. So this is a great question, and it's a critical engagement, even if you don't assert it as much as you could. And I appreciate it. And so I need to think more about my invocation of legal process. What I mean to invoke first, I have I think a more direct answer, but what I mean to invoke is a commitment to democratic institutions, including our court systems, for resolving public law problems. That's where I am. In fact, how do we think about that given social movements, pro-democracy movements, and retrenchment that we're in today? Obviously, these institutions have, depending on your perspective, failed us. Am I hearing this correct?
I have my perspective.
Yeah. So I don't know. I don't know how to evaluate the extent to which they failed us. I started as a telecom lawyer before I got my doctoral degree, and I was writing about telecom and distributional justice concerns. It's also someone, my first job was at the ACLU. I'm getting a little personal here, but I always thought myself, I would be a civil rights lawyer, and then I turned to infrastructure and telecom to make money. But I do believe that these two interests, social justice and infrastructure, are the kinds of things that can only manifest in service of all Americans. And I have a domestic story here, but if we commit to democratic institutions, I mean, that's historically how I experience things, right? I'm thinking about the civil rights movement, thinking about public utility regulation, and that's why I come at it this way. Is maybe, but maybe it's mistaken, and I'd love to know what the alternative is. I really would. One alternative is to think about disaggregated, decentralized finance. I don't know how many of you are, into all that. Middleware, that this is bottom up, user control, that we don't rely on government institutions. And that's what I push back against because I believe that's the formula for a world in which technologists and the industrialists that stood behind the president during inauguration are where they are. So I don't know what the alternative is. I'd love to know what maybe we should go back to the 17th century, 18th century, rewrite these foundational documents in the Anglo-American tradition. I don't know, but if you have a better idea, I'd love to know what it is.
Get back to just the way that you knit together these narratives.
Yeah.
It's just really, really, really compelling, and one of the sort of best kind of big picture and like detailed takes on this that I've seen. So really,
thank you, generous, thank you. But I don't know if it's legal process as such. This is what I'm receiving, and you're absolutely right about that. Maybe I should be a little more tepid about that and just talk about democratic institutions. Yeah,
I also want to echo. I love the canvas and the way in which you frame this. I know that I'm going to want to look into the whole Davos question much more. Totally missed it, and I'm still thinking about it.
I make an allusion to it in the book, but I don't spend a lot of time on it.
I'll look again, but I think it's a tremendous insight because it's also Grateful Dead. How does a guitar get?
That's right.
The Grateful Dead.
That's right. Well, that's an easy one, right? So the user control ethos ideology is not original to Barlow, right? And it's not even original to Stuart Brand. People associate the Whole Earth catalog and the language of user control with him. It's this ethos in the 1960s. It's hippies. And these are the ones that come. I mean, listen, I don't want to be dismissive of hippies. I'm grateful for them for many reasons. But there's an ethos in Northern California that translates into an ideology, kind of our faith. And I don't know if I think I'm parting ways. I'm not answering your question directly.
I'm like, I'd love more context about this. My question is actually more contemporary, but it's an ideology that you're referring to.
Yeah. And it precedes. It arises. It's old. It's not even. We can probably go further back. I loosely invoked Eregibitica, right? Milton, this faith in resistance to government control and prior restraints. That is, to me, I think there's something at work that is very similar to this faith in the polity and the individuals that inhabit it as individuals. And I think I have worries about what that's done when taken to the current extreme. So anyway, but this is something I need to think more about.
That's super helpful. I'm writing about trust and.
About what?
About trust and.
Yes.
So this is helpful. So my question is actually kind of related to a thing that you dropped more recently about kind of the more recent 230 years trusting the platforms to do the mediation versus I feel like your conversation about the product liability lawsuits suggests that trust is maybe shifting.
Yeah.
And can I ask you to pull together all of your work and think about what that maybe means politically? I'm asking very selfishly because I'm writing about this and I feel like you have an
So if you were to, what's the hook you want me to talk more about here?
So I guess, I mean, if you treat the algorithm almost like as an infrastructure that is trusted.
Oh, I see. Yeah.
The content mediation.
Yeah.
Including in part by the Supreme Court when it recognizes its editorial authority. I wonder whether you would see the product liability cases as almost challenging that trust.
Yeah, for sure. Yeah. So you're right. I mean, sounds like you're gesturing to a position on this yourself, but I definitely think it isn't. So these product liability claims and negligent design claims have always been available. And this is why your discussion of trust is actually really important, because this is an extra legal problem. And what is it? Why weren't these conventions available rhetorically or juridically 30 years ago, even though they were there? And so there's something that's happened, and it's related to trust. Perhaps social capital. Tim Wu has a book out, right? It came out last. I don't know if you all had him. His book came out, The Age of Extraction, at the end of last year. I'm grateful for him. He was an interlocutor with me on my book last week, and I'm a huge admirer of his, even generally. Although I have some cool stuff and things, but he talks about his narrative. I think is complements, or I compliment his, I should say. In the age of extraction, is that the companies do something in the mid-noughts, and that is discover the business model and abandon the romantic account of what they were up to, right? Do no evil, or whatever Google's name was, broadcast everybody, which is YouTube's, right? It's very, hopeful concepts, and they abandon it. And so, he levels the blame at I think principally at that moment, and also regulators' failure to employ antitrust aggressively in the years that follow. And I feel like this trust story is something happened, right, where they lost trust. Maybe we can point to Cambridge Analytica, which happens in 2013, but something where the so-called techlash sets in. I'm absolutely on board with this account. What my intervention is different, because I don't want to pin the blame on the companies, although I think they are blameworthy under law, but the failure is ours. The failure is policymakers and that of judges in the 1990s through the 2000s. And the reason this is an important point for me is that these are the same people that can reclaim a position of legitimate authority. All is not lost. The reason I actually have no worry saying something so hyperbolic is because in the past year, the same language is the language of freedom, innovation, and user control is surfacing in the context of AI policy. We have a president who is perhaps the best lobbyist for the tech industry, wanting to preempt state regulation of consumer-facing AI applications. Why? To promote innovation. And there's also this account about competitiveness with China, which, by the way, is what's going on in the 1990s a little bit as well. So I worry that this is resurfacing, and many people like to be, overstate the AI hype without attending to specific applications, right? Consumer-facing applications. This is not about all AI. There are certain productivity tools. There are ways in which we might imagine AI being useful as a matter of course, but we should scale our concerns depending on the risks to consumers. And so that's why I think that we can still stay true. We ought to stay true, and we don't. All is not lost. It is in policymakers' hands. Yeah.
Fascinating, everything. But I have 3 questions. First one. So all these architecture, code, design features, they express business model, as you just said. So what is the space to actually change these features, these design choices through this kind of legal pressure, if it demand business model based on economy, on attention economy, is the same. I mean, is it possible to have structural changes through this legal pressure? Because I'm thinking like about the data protection laws, like people celebrated the GDPR and it made some change. Yeah. But for most people, it's just a cookie that you accept and accept and accept because it's based on target personalization of
That's right.
experience. They need your data and you need the service.
That's right.
So that's the first question. Well, we already had some changes in legislation about data privacy. It don't look like they actually work like a meaningful change. Does the whole addiction debate is going to change the attention economy? This is the first question.
Okay, can I answer that? Can we? Yeah, sure. Because I'm going to lose all these thoughts. Yeah. First, even when at the conference, the roundtable discussion last year, there was someone who came up to me after my remarks, gave me helpful advice, teaches here. He said, you should be careful about the use of addiction when you use a language of addiction, because addiction is a chemical, biochemical process. And we don't have enough research to suggest that that's what's going on. I know that that's what journalists and the plaintiffs' lawyers allege in these cases, but I'm trying hard these days to be careful about that language. I like the language of dependency and codependency, but anyway, just one thing. The other is just more fundamentally on your point. The reason I think that these cases are important is because I do think that they will change the company's design features or the ways in which they think about their design features. How could it not? There are thousands such cases around the corner. This is not a good look for the companies. So I'm not in there. And never mind who's running X. A lot of these other companies are trying to, they're not actively lawless. And so I can't imagine that they aren't thinking seriously about the potential liability risks. So maybe this is hopeful on my part, but I think that this moment in the United States is significant for that reason in ways that the GDPR may not have been. The GDPR, I think, is actually an important moment. California's corollary is important. It's too early to say, in my view. What's worrisome is, the best lobbyist for big tech has been invoking tariff policy to go after EU policymakers, the European Commission, with regards to regulation of AI and penalties under the GDPR. But listen, I'm with you. Like, cookie fatigue is a real thing. I would rather, as you might be not surprised to hear, I would rather we not think about user controls and user preferences, and that we just impose obligations on companies not to hold information for longer than they need, hold companies accountable for only using it for the purposes that they represent, thinking about structural separations that sound in antitrust between different kinds of applications. I mean, this is aggressive regulation, but this is an industry that requires regulation. So I think there's much more we can do.
Okay, so
the second question.
Okay, because one thing that I was thinking, like in the old media broadcasting, if I think that just as a hypothetical perspective, Fox News is intrinsically predatory, I can listen to the NPR as a hypothetical choice of some random user for now. The thing here, I'm not that fan of NPR actually, but anyway, the thing is, do Blue Sky, Mastodon, these new alternatives that has this new speech about users control, do they actually have a business model that is effective? Or good point. So one of the things I say, and actually the advocates of middleware are mindful of, and there is no business model yet has emerged, right? They rely on grants and a subscription, potentially a subscription model, but they don't have a sustainable business model. No one's going to ask me for what the business model should be because I don't know how to manage my own checkbook. But
that is a concern for them. But I have an indirect answer, and that is there are prevailing business models, and that is the market for moderation that exists for the conventional user. Parler is not Mastodon, is not TikTok, right? And so there is something like choice. There are network effects that mean that Meta is very powerful because everyone else is on it. But it's a nice point, and it's just a descriptive one. And I can't tell you why there hasn't been a business model that has emerged.
Yeah, I mentioned that because you mentioned the market, not like the price Hayek hypothesis, but there's also the antitrust mechanism.
Yes.
So all this is
No, I'm all for that. As I think you heard me say.
Kind of question, really quick. My research was with tech workers. One of the main debates are, okay, we need more laws, but the people.
I don't know if we need more laws with regards to labor, by the way.
Yeah, but the idea was to translate laws and code needs to people who are making the laws understand the code, and they don't. That was their main claim. Like you just mentioned, like. Yeah, I'm not sure if what we're calling the middleware is what a software engineer would call it. Mm-hmm. Is this translation process like something that you are concerned about?
Yeah, great point. Are you Brazilian?
Yeah.
I had a Miriam Wimmer, who is in the Data Protection Authority, came to speak at Fordham. And one of the things she has talked about, and other data protection regulators from across the country, talk about scaling up technological capacity. And I was at the FTC as a senior advisor to the chair from 2021 to 2023. And one of the things that I know the chair is very proud of, and I think people who were there are very proud of it, is ballooning the Office of Technology, elevating it to a bureau level, and making sure that there's highly trained technologists working in every matter. So there's a solution for this. By the way, this concern about regulators being behind is not new, right? William Ogburn in the 1920s talks about the cultural lag between radio regulators and radio technology. I know this because my dissertation is about the Radio Act of 1927. This problem is not a new one. This is not an area where we're going to solve it for all time. But I think there are solutions. One is, let's just scale up capacity. I don't know it may be insufficient for you. I don't know if what you ultimately think is, no, there's no use. That may be where someone ends up. There's no use in scaling up this capacity among policymakers because they're just not going to get it. That's pretty fatalist in my view, and we've never really given it a shot in the United States. In fact, we've gone the other direction, right? I mean, we've defunded that capacity. Yeah, I see two hands. Yeah, please.
I'm curious. I mean, I think I've heard you say, okay, the tort angle, and then also maybe regulating these public utilities, like with telecoms.
Yeah, I don't believe in treating these companies as public utilities. I don't think they're utilities.
Okay, well.
I use that as just the kinds of things that brought me to this area. I think about infrastructure generally. Go ahead. I'm sorry.
Well, and then landing on the antitrust.
And data protection.
And data protection.
Yeah.
And I'm thinking about the physical instantiations of the things that people get addicted to that you brought up, tobacco. Well, I guess the gun industry doesn't quite feel the same, but really, I'm getting at casinos, and I'm thinking about how we have all the age checkpoints. There's all these things about if you are a gambler, seek help.
Yeah.
And everybody knows when you go in that you're probably going to lose your money and that you're going to be addicted to the screen.
Yeah.
And it's literally the same, blue light that puts you in the same state as the social media algorithms, and it doesn't stop pushing the button for you if you let it go. But they're not allowed to also store your personal everything and also sell you materials and give you personalized ads. So is there some appropriate analogy to draw there, or just too big a task to say, okay, because before you talk about Section 230, okay, The only thing you have protection for is with regard to the content and the provision of that content. But everything else, all the additional services, all the selling, all the buying that's being done, has to be disaggregated from the model.
Yeah, you basically just summarized the last couple of chapters of my book. I don't talk about gaming, but I think you're not wrong to think about casinos and gaming and the dopamine hit that the companies engineer. I worry a lot about analogies, for the same reason that I think Alito and Thomas are right. So I don't want to lean too much on the casino. I don't want to lean too much on the tobacco. I think we should just talk about these consumer-facing applications as they exist, because they are different also. And their functionalities and the imperatives that drive them are different. So then we should consider the incentives that mobilize them in ways that are different. And data protection, I think, is very important to this. But liability is as well. And I like the way you talked about, cabining the protection to do what the fantastic thinkers in the 1990s were fantastical thinkings that was going on then about user-generated content. So there are ways to do this that don't require that we talk about addiction, that don't, as far as I'm concerned, or talk about too much these other analogs and just treat them as the consumer-facing applications that they are.
So if I were to summarize the straight shot, it's antitrust and data protection.
Narrow Section 230, transparency regulation, tort liability.
Yeah.
That's a lot.
Yeah.
We're nowhere near that.
There's a lot to grow.
It's a lot to grow. It's an opportunity for the future leaders of our country, the countries. Yes, Maria.
But I want
actually there was.
You answered the question.
Okay.
Pretty much the same thing.
Okay.
So building on the data protection proposal, and given that the FTC has changed a lot since Lineker left the agency, where do you see these changes happening? At the state level?
They're happening at the state level. They are happening at the state level.
That's enough for it? Because if you are proposing something.
No, that's not enough. No. But it's nice that it's happening at the state level, in spite of efforts to preempt. So this is an ongoing battle. So I'm happy to see it at the state level. But I argue for comprehensive federal regulation, and it would not alone be enough.
But I feel like the state level initiatives keep being user focused. I know they have norms and provisions.
Yeah.
Data minimization, but in general, they keep focusing on the individual and trying to.
Not always. It's a fair point. Even the GDPR does, right? So I have a critique as an essay I wrote in the Sciences Po law review about two opinions from the European Commission on forced consent. And that's because the GDPR has mechanisms for regulation that are not about user control, not about just user rights. They're structural. Brazil does as well. That is China. Does as well. China's privacy regime also allows government access and surveillance, but that's a whole other thing. So duties that are imposed on companies irrespective of the representations people make. And we don't have that here. Another real quibble then is an example is whether we should have opt-ins or opt-outs. What are the default rules for consumers? You won't be surprised to hear that I think that there should be opt-ins to say things like targeting or monetization. This is not a very popular position with regards to the companies, and I think with regards to many people, because there's a presumption that people ought to be able to effectuate their views or preferences, apart from some heavy-handed governmental intervention. So I think we have a lot of work to do at the level. I have a lot of work to do at the level of persuasion and ideology, and it's the stories we tell. Is that responsive? Okay. Yeah.
Kind of related to that, and going back to one of the first questions, I'd love to hear a little bit more just about your thinking between legal process as a framing versus democratic institutions.
Yeah.
Maybe I didn't follow entirely the super well, but it seems like there's something that you're identifying as significant as the difference between the two. And I would just love a little bit more.
So when I introduce legal process to my first year students, I teach legislation and regulation. It's a very stylized account. And I mean, I hope you don't mind me, Mikey, saying that the version you offered was the stylized account. But you also had a wrinkle on it, which was very interesting. And that is, it's like something anti-democratic. I didn't say that, but I felt like you were saying something like that.
Informed by a democratic anxiety.
A democratic anxiety. And so I received this. And I think that may be where we actually, and I think I agree with you, if that's what legal process means. And so when I talk about faith in democratic institutions, which I think is a better reflection of where I feel, I think it's like reform of the Electoral College. It's like campaign finance, that's also part of it. Just enriching or, creating infrastructures for true democratic participation on behalf of the polity. Is that helpful?
Yeah. So like associating legal process as more like fear of democracy being a little bit too strong.
Yeah, but but legal process is also, the language we might invoke for protection of minority rights, which is why that's why I answered Mikey the way I did, talk about where I come. I mean, I come at this as someone who thinks about civil rights and distributional justice, and democratic institutions have been essential, even if not terribly great, and an utter calamity at this moment. But what alternative is there? I mean, is it revolution? Is that what, I don't, maybe that's what Mikey wants. Or maybe that's what you want. Maybe, I don't know where we end up at the other side of revolution. My family is Haitian. And I love the Haitian Constitution. It leans on the rights of man. Period.
I think the question more so because I really like the framing that you had, like without backing away from legal process, like kind of understanding legal process in this like democratic theory version of it, which is a way of mitigating excessive impositions on one's liberty from like public power. But I also think of like the role of democratic institutions themselves as a way of first mitigating impositions for private power, right?
Yes.
Actually not backing away then from democratic fear.
Yeah.
It's actually like that is a kind of first principle role of of why you have democratic institutions and legal process in the first place.
I completely agree. And maybe I backed off too quickly. I think I need to think more, read more to have a more, a richer answer to the big picture question, which I don't have. But I think I'm gesturing to it, and you both helped with that.